Good afternoon, everyone. This is our delayed panel on surveillance and speech. I'm Judge Andrew Napolitano. I teach constitutional law here in addition to another sort of sub rosa job that I have during the day. Our panelists today are Professor Susan Herman here at Brooklyn Law School, who is also the president of the American Civil Liberties Union, and Professor Jamil Jaffer, adjunct professor at George Mason University Law School, where he is the director of the Homeland and National Security Law Program. So this is the meat and potatoes. This is where the rubber meets the road on cutting-edge First Amendment issues of government surveillance, of government being aware of your speech at the same time you speak it, and if we have time to get into Apple, which I hope we do, of government coerced speech. Professor Herman will speak first, then Professor Jaffer will, and then I will pointedly, even though I have strong and well-known views on this, demonstrate my neutrality by tormenting both of our speakers, and if we can, involving the audience. I see some very, very astute, highly knowledgeable young people in the basics of the American Constitution. I don't even remember who teaches them, but I recognize them, and I know they're ready with a lot of questions that they've been preparing all week. Professor Herman.
Okay, well, thank you very much. Thank you, Judge Napolitano, for the introduction, and also to you and Professor Goyer for organizing such a wonderful day's symposium on the First Amendment. I have to say, moderate was not the first word that came to my mind. Tormenting, I'll accept. So we're talking here about surveillance. So ordinarily, when people think about surveillance, the part of the Constitution that comes to mind is the Fourth Amendment, which prohibits unreasonable searches and seizures. But because this is a conference on the First Amendment, the first thing that I want to do is to talk about the connections between surveillance and the First Amendment freedom of speech, as well as the related freedoms of association and religion. And also, I think about the very deep connection between privacy and democracy. So what I'm going to do, because we have very limited time available here, is I'm going to give you the 3-minute version of what I think is the dominant theme about surveillance today, which is surveillance being used in the counterterrorism operations. 3 minutes, I think, will be plenty. So as you all know, after 9/11, there was a tremendous change in a lot of the law in the country, and one of the major changes that I'm sure you all have heard something about is the Usa Patriot Act. That's the actual name of the act. It's not just an acronym. And what the Patriot Act did after 9/11 was to expand a number of different kinds of government surveillance in a number of different ways. It expanded the Foreign Intelligence Surveillance Act in a number of different respects and enabled more surveillance of Americans as well as people who were non-Americans. It also included, quite famously, something that came to be called the library provision, Section 215, which I see some of you nodding already. What that provision said was that you could require a third-party custodian to give the government records under a court order, any sort of records. And that could be medical records, educational records, and it could be, as at least happened once, a library record like of who checked out a biography of Osama bin Laden. Now, because we don't have the time to really get technical about what's included, I thought I would give this general summary. Right? Can you see the caption in the back? Get me everything on everybody, right? It's a slight exaggeration, of course, but the general idea of the supersized surveillance powers after 9/11 and in the Patriot Act and other authorizations was the idea that the more information the government has, the more likely it will be that the government can disrupt terrorist plots because they'll know things and be able to put things together and connect the dots. So the idea was this sort of dragnet thinking: we'll scoop up a whole lot of information and then it will be easier to disrupt terrorists. Well, when George W. Bush left the White House, a lot of people said to me, oh, that Patriot Act, is that still around? Didn't President Obama change all that? Well, the answer is not really. Can you read that one at the top? Okay, yes, we can. Okay, so President Obama's surveillance policies have not been really all that different from President Bush's. We could talk about how, but that I think I'm going to skip over in the interest of my staying within my 3-minute history here. Okay, so there's the Patriot Act. We're 14 and a half years now after that. There was a whole lot of surveillance. There was a whole lot of talk. A lot of people accepted this basic idea of we have to give up some privacy and some liberty in order to be safe. And then comes Edward Snowden. So Edward Snowden starts revealing all these papers showing that there's a lot more complicated surveillance going on than people had known about. all different, we could spend a very long time, we could spend an entire course talking about all these different kinds of surveillance that were going on. But what happened after that was that I think because of Edward Snowden, there was a new discussion that was triggered about the costs and benefits of this surveillance model for disrupting terrorism. Part of that discussion was, well, what really are the benefits? Are we getting a whole lot of prevention of terrorism? What are we getting for having all this surveillance? And it turned out that that's a very complicated question for a couple of different reasons. One of the reasons is that it's all happening behind closed doors. There's a point where they call this covert surveillance, right? So we don't really know what the government has been doing, and it's very hard for me or for any of us to evaluate whether the government actually has disrupted terrorist plots or to count how many there have been. The second problem, I think, is that if you're talking not just about catching people who've already done something, but about preventing somebody from doing something, that's pretty hard to measure, the prevention. That's sort of like measuring a non-act. But we had reason to question whether this program of all this surveillance was as effective as Congress, I think, had believed in the fall of 2001. Keith Alexander, General Alexander, who'd been the head of NSA, had been giving speeches and told Congress that he could point to, he had 54 different examples of where terrorist plots were disrupted. Well, when that number was investigated, there was a big analysis of this in ProPublica. A number of different people analyzed that figure. And what they said is, maybe you could identify 4. And in all those cases, nevertheless, they said, and there were Senator Wyden, for example, who was on the Intelligence Committee, said he wasn't even clear that even if you could say that information the government had obtained through some of the controversial surveillance programs had contributed to disrupting a terrorist plot, it wasn't clear that that was a necessary means of getting that information, that it may have been possible to get information in other ways. There are a number of Inspector General reports where they also were allowed to look at some of the secret documents, and they also raised a lot of questions about what benefits are we really getting from all this surveillance. But where I want to go with this is in terms of the costs. So there have already been some consequences of the debates post-Edward Snowden. One was that the ACLU brought a lawsuit claiming that some of the bulk metadata surveillance, collecting get me everything on everybody's telephone numbers, was illegal, that it wasn't actually authorized by the Patriot Act statute that the government was relying on. And I think that partially as a result of that litigation, as a result of the public discussion, Congress then passed the USA Freedom Act, and that is an acronym, that's not the actual name of the act. You can see somebody really worked hard. I actually met the guy who worked hard on that acronym. But what they do is there are minor changes, to me, fairly minor changes about who's actually possessing the data. Significant, but not as great as we would have liked to see. So I want to talk, in my remaining 4 minutes or whatever, what I want to talk about is not the benefits, which are extremely hard to quantify, but what I want to talk about are the costs of this surveillance power. And I want to talk about that in terms of First Amendment, as opposed to just privacy. Is somebody going to see you in the shower? One of the questions that I'm very often asked about all this is, why should I care what the government knows about me if I'm not doing anything wrong? And the corollary to that is, why should I care what the government knows about me? There's no privacy anymore. Amazon and Facebook know everything about me, so who cares? Well, I think there's a pretty big difference between the government and Amazon. So the last time I looked, Amazon could not put you on a no-fly list if for some reason something came up about you that was interesting or that made them suspicious. This is a case that the ACLU brought on behalf of a number of American citizens, as you can see, including a number of veterans, who were exiled and couldn't get home from out of the country because they were put on the no-fly list for reasons that they did not understand. So Professor Gora mentioned this morning the whole problem of having too much surveillance, creating a chilling effect, creating problems for people. Well, if you're concerned that if the government knows things about you that they might find suspicious and they might put you on a no-fly list, you're going to start pulling back. You're not going to join controversial groups. You're not going to investigate Osama bin Laden. You're not going to plan a vacation in Yemen. There may be ways in which that's going to affect your behavior. One of the surveillance powers that the government had was financial investigations, that they could go through all sorts of financial records, again, on this sort of third-party theory that you had shared your information with the bank, and therefore the government could look at it all. This is a report that the ACLU did about the government, and this is mostly under the previous administration, looking hard at virtually any Muslim charity to try to figure out, whether anybody who had given to a Muslim charity might therefore be traceable to some sort of terrorism. And there are documented cases all throughout this report of Muslims who were, doing nothing wrong. They were contributing to charity, which is a pillar of faith in Islam. But they found FBI agents on their door questioning them about why did you give to that charity and would you do it again? And so a lot of these people reported that they were feeling chilled, that they felt like they couldn't give money to a Muslim charity or they were going to have the FBI on their door. It also caused a lot of people to feel like they didn't really want to cooperate with the FBI. They began to see the FBI as their enemy more than their friends. Another provision in the Patriot Act, once all this investigation had gone into financial dealings, was that the government was permitted to seize the assets of an organization with no hearing indefinitely while they were doing an investigation. So this is another ACLU case that was brought, interesting background story that I'm not going to have time to tell you, but if you want to look up the case, this organization had its assets seized for several years, just pending an investigation. So again, are you going to be a charity? Are you going to give money, as this organization was, to places in the Middle East if you might attract the government's attention, and therefore they might just decide to seize your assets? I want to now go back to, I'm jumping around a little to try to be fast. The first attempt that I've seen to try to quantify the chilling effect is a very interesting survey that was done by PEN America, the world's largest organization of journalists and writers. And they sent a survey to their members and they asked them questions like, post 9/11, being aware of all this government surveillance, have you curtailed or avoided social media activities? And 28% said, yes, I have. An additional 12% said they had seriously considered doing so. That's 40% of this highly educated group who are saying that they have self-censored. 24% said they had deliberately avoided certain topics in phone or email conversations. Another 9% had seriously considered doing so. 16% avoided writing or speaking about a particular topic, and another 11% have seriously considered it. Well, this survey was so interesting that PEN also tried to do the same thing on an international level, which I'm not going to detail for you. So I think there are a lot of examples here of how it is that all this surveillance really does lead to a chilling effect on freedom of speech, freedom of religion, freedom of association. I will tell you one other thing in terms of the First Amendment. This man, Nick Merrill, was an internet service provider in New York, and he received a national security letter, which is a demand for information that doesn't even have a court order behind it. He's holding his national security letter in a picture he had taken for my book, which you can see is redacted. You see the black splotches. And what Nick was concerned about was he was asked to provide information about one of his clients, one of his internet clients. He has never said publicly who that client was, because that, he understands, should be secret. But what really bothered him was, first of all, there was no court order. This is just do it yourself. The FBI commanded him to turn over the records. And second of all, what the Patriot Act provided was that if you received a national security letter or one of these library provision orders, you were under an absolute gag order. Nick was not allowed to tell anybody that the FBI had asked him anything. And he litigated this case. When he first came to the ACLU, he talked to one of the lawyers there, and he said, so if I challenge the government on this, is someone going to put me in a sack and drag me away? And the lawyers had to tell him, it wasn't really clear what would happen, but he agreed. He decided that he wanted to challenge the government. So for 6 years, he had a case pending that was called John Doe versus. First it was John Doe versus Ashcroft, then it was John Doe versus Gonzalez, then it was John Doe versus the Attorney General kept changing. But Nick, for 6 years, was not allowed to tell anybody that he was the plaintiff in that action. Victor Marrero, who is the judge in the case, came out with a very interesting ruling, which some of you may see at some point. And Nick said to me at one point, he said, gee, he sounds like a great guy. I wish I could meet him. Nick had not been allowed to go to the court hearings, because what if somebody figured out who he was? So there's a lot of very deep secrecy here. One reason why I'm happy to talk about Nick is that he decided, in light of this experience, to create a privacy-friendly internet company. And he is a client of the Brooklyn Law School Blip Clinic. Is Jonathan Askin here? Oh, there you are, Jonathan, which is run by Jonathan Askin. So, we have a very close connection with Nick Merrill. Okay, so in the interest of time, I just want to tell you about one more person who was actually prosecuted because of speech. Sami al-Hussein had been making donations to a Muslim charity, and the government decided to prosecute him for providing material support to terrorists, but they couldn't quite figure out which terrorists. First, they accused him of supporting al-Qaeda, and then they decided they didn't have proof for that. So they said he was supporting Hamas, and then they moved to Chechnyan rebels. And then by the time they got to trial, I don't know, what investigations had actually happened, but what they charged him with was they charged him for material support of a terrorist group because he was running a chat room on a website for a Muslim organization at the University of Idaho where he was a student. That was it. He was posting things on a website. And he posted, to be fair, all different views about Islam. So he posted some jihadist points of view about themselves and just all sorts of things about moderate Islam. He himself had led a candlelight vigil at the University of Idaho after 9/11 to express sympathy with the victims. So the government prosecuted him for running this chat room. One of the government's own witnesses said, well, if that's true, the New York Times should be prosecuted for publishing an op-ed written by Hamas explaining their point of view. The BBC had published a lot of the same links that Sami al-Hussein had published. So again, much more complicated story behind the case, which I tell in my book. If Rick can hold up his book, I can too. Right? Also available on Amazon. Make sure you get the updated paperback version. But the bottom line of the First Amendment claim, Sami al-Hussein's lawyer moved to dismiss that prosecution on First Amendment grounds, and the judge denied the motion, saying an opinion would follow. No opinion ever followed because you can't write that opinion. But what I can tell you, the piece of good news out of this to me, is that an Idaho jury, retired forest workers, the folks of Idaho, the defense attorney made the First Amendment argument to them, and they acquitted him on the material support charges. There were other issues that were going on about immigration. So a lot more stories about the First Amendment, which perhaps we'll get to later. So I think I want to end on one of my favorite quotes, which is really now connecting this, the surveillance, not only with the First Amendment, freedom of speech, association, and religion, but with democracy itself. And this, I probably tell, is not written by a lawyer. Elaine Scarry was teaching English at Harvard at the time. And she says, the Patriot Act inverts the constitutional requirement that people's lives be private and the work of government officials be public. It instead crafts a set of conditions in which our inner lives become transparent and the workings of the government become opaque. Either one of these outcomes would imperil democracy. Together, they not only injure the country, but also cut off the avenues of repair. So, I've been giving a talk some places that I call Benjamin Franklin's desk. And I think that when we get to Apple and things like that, the smartphone is now where Benjamin Franklin would have kept all of his information. The Fourth Amendment was meant to protect the contents of Benjamin Franklin's desk, right where he had his seditious literature and whatever it was he was doing. And the whole idea, I think, that the framers had in the Fourth Amendment is deeply connected with the First Amendment, freedom of expression, freedom of thought, etc. So I think that the framers would have been very interested in the debates that we're having. We talked before about originalism, about the protection of what happens in our telephones, because I think that they saw that not only as a matter of privacy and the Fourth Amendment, but as essential to our freedom of speech and to our relationship to the government in a democracy. So thank you.
Professor Jaffer, there's a line in the sand and it's been drawn.
So I'm going to try and, can you hear me if I'm on the recording, if I sort of pace a little bit? Is that all right? Do I need to use the microphone or are we good?
You're okay.
We're good? All right, awesome. So actually, is it possible to get that slide back up there? So I think I'd like to start, and I'll keep this very short, and then we'll get into more of a conversation, I think, with Professor Herman and the judge. But it's interesting to compare Brandon Franklin's desk to the iPhone. I think the comparison is exactly apt, right? What I would say is it's as though you allowing Apple to prevent the government from getting into the iPhone is just like saying to the government, even if you had a court order, it is like Brandon Franklin's desk. We created the Fourth Amendment, and we said
The last one that was up there.
to get into that desk.
You can go back to the overall, do you want one of those, Jamil, or
The
you want
last
to go back?
one.
The last one, the desk.
Last
Go
one.
forward,
Last-
forward, Lloyd, it's the last one. No, you're going backwards, go forward.
We're almost there. There it is. Oh, there we go. All right.
Hard
So it's just like getting an event like this. The rule has never been in America, you can't get an event like this. The rule is you have to go to a neutral third-party magistrate, show probable cause of the crime has been committed, get an order from a judge, and then you can rifle through all of Ben Frank's desk. You can get all his personal papers and read everything. That's the American rule. And so what did the government do here in the case of a known terrorist killed over 14 people in San Bernardino's cell phone? They went to a federal judge, they asked for a warrant, they got a warrant. They used that warrant to go search his car. They then got in the car and found a phone. They had authority to get to that phone too. That warrant provided the same authority, however, the phone was locked. So they went to the judge and said, hey judge, I've got an order to get the phone. And they got one. Apple refused to comply. It was almost as though the maker of Ben Franklin's desk had decided after 4 times it pulling in the drawer, 10 times in the case of Apple's iPhone, pull the drawer, we're going to super glue the whole thing shut. And you can never get in without blowing the whole thing up and you lose all the papers. That is essentially the equivalent of Ben Franklin's desk and Apple's changed iPhone. So maybe you think, well, this is a good idea. This makes sense. We care about privacy. We care about security. I'm worried that if a bad guy gets their hand on my cell phone, I want the cell phone to be wiped after 10 tries, so I don't want them to try breaking in. Makes perfect sense, right? Well, of course, the problem is that the government here is not saying, hey, give me a key to every cell phone. Give me a key to every iPhone in the world. They're saying, let's get this one iPhone, and let's try all the keys on our keychain. We try 100,000 keys. We, the government, have this great supercomputer, we can plug it in, try a bunch of tries. All we want is a chance to not have that door, or the drawers of Ben Franklin's desk, as it were, super glued shut. Seems to make sense, right? A lot of good reasons why you might think you don't want that, but a lot of reasons too why the government might need to have that capability. It's not going in the back door, it's using all the keys in the front door. But let's talk about the 215 program and 702 program and government surveillance writ large, right? Now, Professor Herman talked about the dragnet surveillance. The notion that everybody's being surveilled at all times. All of your information is in the government's hand at all times. You have no privacy. It's interesting. Another well-known, well-regarded person made similar statements recently. Ted Cruz has the same view. He recently said at a public rally, he campaigns, look, everyone take out your phones so President Obama can hear you. As though the president or the National Security Agency or government agencies were listening to everybody all the time. Of course, as we found out from the Snowden revelations, none of that is true. The government, in order to surveil America, has to have a court order, no matter where they are in the world, required by law. In fact, the protections for Americans were increased in the FISA Amendments Act, whereas abroad, you only needed an Attorney General authority to get surveilled American. Now, post-FISA Amendments Act, you need a court order anywhere in the world for an American. So notion of government doing dragnet surveillance for Americans, not true. At least on the content of the communication. Now, we'll talk about the 215 program. We'll talk about phone numbers and metadata and all the things you can tell from metadata, and to be sure there are challenges there, and to be sure the government did engage in mass surveillance of phone numbers and emails, so an email metadata. So we can talk a little bit about that. But as to content, it's not true. The government is not listening to you all the time, nor read your emails. Just not true. Now, is it true the government collects a lot of information? Of course. Does the government conduct dragnets anywhere in the world against any group of people? Almost certainly not. Why not? Doesn't make sense. No matter how powerful supercomputer you have, no matter how much capability you have, you can't take all the data all the time. It's just too much. Not only is it too much to intake, it's too much to process. Not only is it too much to process, it's too much to translate. No matter how much you can translate, it's too much to analyze and reduce to actual intelligence. So conducting surveillance in the way that folks would have you believe, dragnet surveillance all around the world, is just not effective, nor realistic, nor the actual way the government conducts surveillance. As we've now learned through the Snowden revelations, in fact, the government doesn't conduct dragnet surveillance. It uses things called selectors, email addresses, phone numbers, whether abroad or domestic. It identifies somebody they want targeted for collection. In the case of an American, they get a federal court order, and then conduct that surveillance. In the case of foreigners overseas, they have to determine their foreign intelligence value and then task it under one of the FISA Amendments Act orders. So there is no dragnet surveillance going on. There is no mass content surveillance going on because it's not effective. It doesn't make sense. And so we talk about, well, what about the benefits and the cost of benefits? And we say, well, the benefits of government surveillance are hard to quantify. We can't tell how many terrorist plots have been stopped because it's all happened behind closed doors. Well, to be sure, intelligence collection happens behind closed doors, as it should. If the terrorists knew we were surveilling them, they would stop using that means of communication. As we found, by the way, in the case of all the Snowden revelations. Intelligence collection has dropped off dramatically post-Snowden. Because he revealed the sources and methods by which the U.S. government conducts intelligence collection domestically and overseas. Edward Snowden was claimed to have been worried about surveillance of Americans, and yet he revealed tremendous amounts about surveillance overseas conducted against foreigners and terrorists. Details, sources, methods, actual technical capabilities of the U.S. government. To be sure, he revealed an important program that we've now changed the law about, the 215 program, which affected Americans. But he revealed terabytes of information about overseas collection programs that had nothing to do with Americans. And we allowed him as a hero. Our intelligence collection against terrorists and foreign intelligence operatives and foreign governments overseas has dropped off dramatically. And yet we wonder, okay, what about the benefits? Well, the government has actually, in fact, identified 54 plots, most of them overseas. The Germans were actually huge beneficiaries of our collection programs, notwithstanding their concerns about the way we collect information. I would note, by the way, the Europeans who claim all these concerns about American surveillance and the like conduct their surveillance for national security purposes with no court in between them and their order, with no oversight from an independent magistrate, no oversight from the legislative branches, complete open surveillance. And yet, the Europeans criticize our surveillance regime, which operates with court orders, with judges, with oversight from IGs, from Congress, and the like. And in fact, on top of all of that, when you look at the actual plots that are constructed here in the United States, we've identified 11 plots constructed in the United States. Now, it's true. Not one of them, in not one of those cases was the information collected from the FISA Amendments Act or the 215 program a silver bullet. But of course, that's never the case. Intelligence is about silver bullets. It's about little, bitty, eensy-weensy pieces you put together to try and draw a mosaic, and draw a puzzle. Anybody who's ever worked in intelligence will tell you there's no silver bullet intelligence. It's trying to figure out the overall picture. And so it's not surprising we say, well, there's no proof that this one piece of evidence was a necessary and sufficient condition for finding that plot. It's never going to be the case. If that's what you expect of our government operatives and our government surveillance, it'll never happen. Might as well just end it all. And one surveillance before I'll sit down and we can fight about it. We talk about the fact that it's hard to quantify benefits. But then we decided we're going to quantify the harm. And so, could we go back to the slide that showed the
pen study?
Yep.
Yeah,
right, next slide.
one forward, yeah.
So we talked about, well, we can quantify the harm to privacy and civil liberties, and in particular here, the chilling effect on speech. Right? This is a survey of reporters. 28% curtailed their social media activities. They're not on Twitter as much. They're not on GChat. They're not on Instagram. The thing that matters, they've deliberated some avoided some topics in phone or email conversations. 24% of them avoided it. 9% have seriously considered it. On the thing that matters, their writing, 16% have avoided writing or speaking about a particular topic. 16% of reporters. That's something quantifiable. Doesn't sound like a lot. Doesn't sound like a huge, dramatic, oh my God, speech has been chilled. The world's come to a crashing halt. Free speech is dead in America because of government surveillance. This is post-Snowden. This is after all the revelations, all the drama, all the upset, all the anger. 16% of reporters have avoided writing or speaking about a single particular topic. 16%. So, you're right, we can quantify the downside. We can also quantify the upside. There hasn't been a terrorist attack in America, other than the San Bernardino attack and arguably Fort Hood, since 9/11. 16% of people stopped writing and talking, reporters, no terrorist attacks since 9/11. I'll take the national security side.
Well, there certainly is a line in the sand. There's no question
I think it's many lines in the sand.
No question about that. And I want to try and keep it on the First Amendment side, even though there are many, many, many Fourth Amendment issues here, because as we know, the standard for obtaining a search warrant under FISA is not probable cause, which is what the Fourth Amendment requires, but it's a far lower standard. In fact, under the so-called USA Freedom Act, which Senator Cruz, who claims to favor the Constitution, authored, the standard is even less. But let's stick to the First Amendment implications here. How do you address the Patriot Act's absolute, Professor Jaffer, the Patriot Act's absolute prohibition on the revelation of the receipt of a national security letter? Now, a national security letter is a fancy phrase for a search warrant written by one federal agent authorizing another federal agent to do the search. There's no probable cause shown. There's no involvement of a judge whatsoever. You have made an articulate argument that this serves national security purposes at a minimal violation of the Constitution. But what conceivable justification could there be for the prohibition on telling everyone, a priest in confessional, a lawyer in court in the lawyer's office, a judge in an open courtroom, a spouse in the bedroom, a neighbor, a person in the media? What conceivable justification could there be under the First Amendment for the prohibition on revealing the existence or the receipt of the self-written search warrant?
Sure. So, well, let's real quick talk about what the national security letter is and isn't, and then we'll talk about the so-called gag order. So, national security letter allows the government on the certification of a senior FBI official to obtain from a service provider, typically phone numbers and billing information for telephone records. Other kinds of records are also available in NSLs, but primarily the primary use is phone records and identifying information about the user of the phone system. Now, it's less a warrant, actually a self-made warrant, and more a self-made subpoena, which, by the way, U.S. attorneys issue all the time. They have a stack of them in their drawers. They pull them out. As long as there's an open grand jury investigation, they sign them. No judges involved.
We're talking about the gag order, not the Fourth Amendment applications.
Fair enough, but you raised the issue of this was a self-addressed warrant. It's just like a subpoena, which is a self-addressed request to order to provide information enforced by a court, just as the NSL is. Now, but let's start with the gag order, because I know that's the point you wanted to make. Gag order has been struck down 4 times, 5 times? Modified
I think Victor Marrero struck it down.
Multiple
Judge Marrero
times.
struck it down.
Judge Marrero, but before then even has been struck down a number of times, and Congress has gone back and rewrote it, right? Because the gag order, at least as applied to talking to your lawyer, right, and talking to other certain individuals, couldn't be made consistent with the Fourth Amendment. So Congress went in, the First Amendment, and modified it. And ultimately, the gag order is what it is. It's still being litigated, right? But let me explain why. Why do we have a gag order, right? And I'll analogize it to the scenario we faced when we litigated with Yahoo in the FISA court and the FISA court review. It's now been revealed that the litigant was Yahoo, but at the time we conducted the surveillance and we litigated the case with Yahoo, their name was classified, and ultimately we declassified the opinion in that case, but we left Yahoo's name out, and we also redacted the name of their lawyers. Now we can all talk. It was Mark Zwillinger and his team at Zwilgen. But at the time, we had redacted both Mark and his client's name. And the reason why was, had you revealed who the provider was, it made it more likely that individuals that you wanted to surveil would not use that provider. And as it turns out, when it came out that the U.S. regularly serves orders on companies like Google and Microsoft and the like, terrorist and other foreign intelligence services use of those services dropped off dramatically. And we lost surveillance.
Okay. So
that's the reality. Now,
I want to switch to Professor Herman. Professor Herman, I think Professor Jaffer's argument is the minimal, and I'm going to make it as I think you would in a succinct way. The minimal interference with First Amendment liberties is worth the societal benefits that come about as a result of that interference. And he further argues that those societal benefits are the substantial diminution in terrorist attacks in the United States since 9/11. How do you address that argument?
Well, I would start by saying that I think that argument works only if you regard the First Amendment as minimal. The gag order was absolute, as Professor Jaffer was saying at the beginning, and nobody was allowed to say anything. You were not allowed to tell anybody that the FBI had ever come to you and asked you a question. The government's theory was what was known at the time as the Mosaic Theory. Any tiny little piece of information that the public can find out about how the government is going after terrorists might help the enemy, and therefore the public can't know anything. Right? So that, to me, that's the Elaine Scary argument. That's really scary, right, if we can't know what the government is doing and they get to find out everything about us. The gag order was very slightly modified because the government did realize that it was not defensible to say you're not even allowed to tell your lawyer that this had happened. You're not allowed to tell the technicians who you need to comply with the order. You're not allowed to tell a judge. So Congress, after Nick Merrill's lawsuit, and Judge Morera's opinion, did very slightly change the gag order so it's not absolute. I won't go into details, but it's still, almost absolute, and it's still granted in 97% of the not granted. But it's possible to challenge it, but under very narrow circumstances, and if the government says, well, we don't want it challenged here, that's final. So let me give you another example of what happened because of the gag order. It wasn't just that Nick Merrill for 6 years couldn't tell anybody that he had brought this lawsuit. His girlfriend broke up with him because he said that every time he went to court, he had to lie to her, and he had to hide the papers where she couldn't see them, and she felt he was hiding something from her. Go figure. So in addition to that, one of the chapters in my book is about the librarians, and right after Nick Merrill's case, there were some librarians in Connecticut who wanted to, they received a national security letter, and it's not only telephone records, it's about computer records as well. And think, what does your internet service provider know about you? This is pretty big in terms of all the data there. But the librarians wanted, at the time, the Patriot Act provision in question was up for renewal because it had been sunsetted, and they wanted to testify in Congress about the fact that, in fact, these things were being used in libraries because at the time, Congress was under the impression that Section 215 was never used in libraries and therefore there was no problem. And they wanted to tell Congress, well, maybe they're not using 215 in libraries right now, but they are asking for these all other kinds of information. Because of the gag order, these librarians were not permitted to testify in Congress. Now, that to me, that's really related to democracy. The Mosaic Theory, it's very hard to say. Nick Merrill always, as did the librarians, they totally respected that they were not going to say who was involved. And the idea that if the public can know anything about the government's methodology of surveillance or anything else, that's going to be too helpful to the enemy, and therefore we can't know and they can't talk, that's just not democracy.
All right, before we go to the audience, I'll ask each of you one more question. Under what theory could Congress, each of the members of whom has taken an oath to uphold the Constitution, come up with the value judgment which you just very forcefully and compellingly articulated, that the loss of liberty is worth the increase in safety? Congress isn't, can you address the argument that Congress is without the legal authority to make that value judgment because Congress is subject to the Constitution, not in a position to tinker with it?
Of course. So of course, in this context, we're talking about primarily two provisions of the Constitution, the First Amendment and the Fourth Amendment. I'll talk about the Fourth Amendment because it's really the core one here, but this is the First Amendment panel, so we'll come back to that. The Fourth Amendment doesn't bar all searches. It only bars unreasonable searches. And it permits searches explicitly with probable cause and a court order. And I would note the probable cause actually is a requirement in FISA, but it's probable cause to believe you're a foreign power or an agent of a foreign power. So
right.
it is a lesser standard, I will grant you.
It's a substantially lower standard.
It is a substantially lower standard, I will grant you, as it should be in intelligence cases. And in fact, the Supreme Court has never held this, but every court below the Supreme Court to address the question has held that, in fact, you don't need a warrant at all, nor no court order whatsoever for national security surveillance. But, and the Supreme Court has left that question open.
To Congress making value judgments that are articulately not Congress's to make.
So in the search scenario, right, the Constitution explicitly acknowledges that Congress will make that value judgment, that it will determine what constitutes reasonable and unreasonable, and then the courts will have a chance to review that and determine was this an unreasonably authorized search or not. In the First Amendment context, the Constitution is much more explicit. It says Congress shall make no law. But of course, we know that no law doesn't really mean no law, with the exception of certain theorists who argue that in fact no law means no law.
Are you rejecting originalism?
No. I have some sympathy for that position, right? But we have never, as a nation, accepted that position, not since day one of the Republic. And if you go back and look at the originalist history, in fact, I think that they would acknowledge no law didn't really mean no law. It meant it's not speech. If in fact you're yelling fire in a crowd.
Okay, I think we get the argument. Here's one that I hear a lot.
May I answer that question too? Were you going to ask me something different? Or
I was going to ask you to respond to that. I was going to ask you another question that would be more challenging. This one's right up your wheelhouse, but go ahead.
Okay, what I wanted to do is I wanted to answer that by using the Apple, incident as an
Please.
example, because I think that's what the audience is going to be interested in. So in terms of whether Congress can make value judgments and legislate about things in the Fourth Amendment or First Amendment area, they can, as long as they provide more rights. So what's very interesting about the Fourth Amendment history is that Congress has consistently found that there are more rights, by statute, until the Patriot Act, than the Supreme Court has. The Supreme Court bought into this third-party doctrine, said whatever. Congress was more protective. What I think is missing from a lot of the discussions about the Apple incident is that the All Writs Act is supposed to ask people to comply with the law, but there is no law here because Congress has not made the value judgment that Apple should provide a backdoor and that we cannot have encryption. There's a 1994 act called CALEA, the Communications Assistance for Law Enforcement Act, in which telecommunications, the traditional telephone companies, et cetera, are required to provide assistance to the government surveillance. The FBI reported to Congress in 2009 that they were having a problem because, in fact, that didn't cover things like Apple and cell phones and so forth. But to my knowledge, there's never been any legislation introduced even to amend CALEA to require Apple to do what the government is now asking Apple to do. There are, in fact, acts that are pending in the bills that are pending in the Senate and in the House called the Secure Data Act, suggesting that what Congress should do is to make the value judgment that, in fact, we should have a right to our privacy and that the government shouldn't be able to get everything every way that they want.
Well, that's a value judgment you would argue Congress can make, but it cannot make it the other way.
That's right, they can't. And I think that if Congress made that judgment, what Apple is now saying is let Congress decide. If Congress wants to say, we do want to extend CALEA and require you to build this back door, then there would be constitutional challenges. Jamil has talked about the Fourth Amendment. It's not the only right at stake. As somebody was saying this morning, there's a First Amendment challenge, that code, that software is speech. There's also a Fifth Amendment challenge, that Apple is being conscripted and being forced to be a government agent to help out in a way where...
That would be a 13th Amendment challenge of involuntary servitude.
That's been said too.
Are we finished with time? Okay, questions or comments from the audience? I can't believe there's none. Yes, young lady. To the argument that software is speech? There is a Ninth Circuit opinion, it's not on this subject matter, characterizing software as speech. So Professor Jaffer first. If the court order were to be enforced, would that not be a case of forced speech against at least a half dozen Supreme Court rulings?
I mean, it's a non-trivial argument. I mean, if money is speech and if all these other things are speech in the broader rubric, it's there's a lot of creativity that goes into computer code. It's a non-trivial argument. I don't think you can just dismiss it, up front.
Professor Herman.
Well, I do think that software and codes are a form of speech. I mean, it's a form of creative production, as all of our BLIP students know very well. One of my dearest colleagues on the faculty here once referred to me as a technological dunderhead, which I hope was fond. But what I don't know enough about, I don't know enough about the technology here to understand what Apple, there are a lot of different contentions about what Apple might or might not have to do in order to comply with the order. I think certainly there's a
unless
First Amendment
Professor
argument
Gora
in the
is
Senate.
going to give us the next panel's time, we're going to have to stop it at that. The technology is fascinating and disputed. Apple claiming that certain things will happen and the government saying certain things won't. It's a very, very excellent sign of serious and intelligent minds when they can disagree so agreeably. Thank you very much.